everyone, and welcome to Clocking In with PilieroMazza, Labor and Employment News for Government Contractors. I'm Nicole Atala, a partner with PilieroMazza, and I'm here with my other partner,
Sarah Nash. Hi, everyone.
Hi, and today we're going to talk about severance agreements. We've received a lot of questions about severance agreements and how a National Labor Relations Board decision, NLRB, lots of words there, affects severance agreements. Questions like, how does this impact what I currently have? What's going on here? Are they enforceable? How far does this reach? So today we're going to break down that board case. We're not going to bore you with all the details, but I do think, and Sarah can get into this in a moment, that we had this case that dropped. There were some initial questions about it, and then we got a letter from the general counsel that kind of dove in a little bit more into how they're interpreting this decision. And like many GC memos, it was a little bit broad and a little bit scary. So Sarah, what was this case kind of getting at?
This case is McLaren-McComb, and this is a perfect example of how a lot of folks think that the National Labor Relations Act just applies to unionized workforces, just applies to unions. You don't have to worry about it if you don't have a union on site. This is a great example of how that's not the case, right? So under this decision, the board has reached a determination about certain severance agreements and the releases within those agreements that the board is saying often chill employees' Section 7 rights to engage in protected activity. If you're not familiar with sort of the lingo that is the National Labor Relations Act, employees are protected in certain activity that involves discussing their wages and other terms and conditions of employment. And as you can imagine, there's sometimes some tension between a waiver or release, especially confidentiality claims that might go hand in hand with the severance, and that same principle that employees have a right to discuss their terms and conditions of employment. So recently in this board decision, the board agreed essentially with general counsel and with the decision that was brought that these severance agreements had chilled employees' right to discuss their terms and conditions of employment, and found essentially that you can't limit employees' ability to talk about certain things. So that's really big picture what we're looking at in this situation.
So is it like the whole thing? Like, how does a release itself impact or chill speech? Or is it just certain parts of the severance agreement that the case is worried about?
Not so much the release, although you do have to be careful to carve out an exception for bringing certain claims under the National Labor Relations Act. Really what we're looking at the non-disclosure provisions or confidentiality provisions, which say you can't talk about this. And secondly, the non-disparagement provisions. And just because you have a severance agreement doesn't mean that you have to have a confidentiality provision and a non-disparagement provision, but they are fairly typical in this setting because understandably, you don't want parties necessarily walking away from the decision and discussing how much they were paid, whether they were paid off, and speaking badly about the company.
I mean, especially in the context of, we don't really think this person's owed a severance anyway. We didn't do anything wrong, but we also don't want this person out there bad-mouthing us. And we want to make sure that that's worth something to employers, especially in the era of like Glassdoor and client satisfaction. So certainly non-disparagement provisions are important. Now, does this apply to everyone in a workforce, or there's certain, I know this is a loaded question and you already know the answer, which is why I'm asking it.
Well, I'm glad you asked it. Happy to answer that question for you, Nicole. So no, National Labor Relations Act does not apply to all employees, just those non-supervisory employees. And generally a supervisor is going to be defined as someone who has the authority to make hiring and firing decisions, or at least give recommendations as to what those decisions should be, someone who is regularly monitoring employees and imposing discipline. Those supervisors do not have the same protections that rank and file folks do. And so if you have severance agreements for your executive folks, those are still fine. They are not impacted by this decision, at least not yet. The general counsel has been very vocal about expanding the reach of the act recently. And that's really what this memo that was recently issued discusses. Essentially, they say, yes, everything within these confidentiality provisions and non-disclosure provisions is potentially something that can chill employee speech. They even went a little bit further than the board did in their decision. They essentially said, even by including these, it's so likely to chill employee speech if you have a carve out for NLRA activity, that might not be even enough. And so they sort of, Nicole and I have had conversations about whether that's even enforceable in the scope of what the board is limited to look at, but they are looking really critically at these types of decisions.
Right, especially like in a non-disparagement context, it kind of insinuates this like standard for which non-disparagement is okay. Like it has to be malicious and intentional, and it's got to be like really seedy, you know, in order for you to prohibit it. But what about this concept of retroactive application? They've made pretty clear that this applies, even though it overturns the decision in 2020 that basically said, no, we're not really going to touch this stuff. They've said, no, it's retroactive. You know, it's going to apply to anything you signed before. So employers will often ask us, well, what do I do about, like, I'm not going to go back to the employee I signed a severance agreement with 5 years ago and like update their non-disparagement obligations. Like, we're not going to open that can of worms, right? So like, you know, to what extent do I have to worry about those people coming back and saying, well, this thing is invalid? Like, what would an employee have to do to really make this an issue?
Well, the first nice good news is that under the NLRA, there is a limited statute of limitations, and that's generally going to be 180 days. There are exceptions for continuing violations, but in the instance of severance agreements, you sign the agreement, it's pretty concrete. That's when your 180 days, 6 months starts. So anyone who has, you know, signed these severance agreements more than that period, you're probably fine with. Then you're looking, at this look back period of the last 6 months or so, whether you have, signed up with employees to this type of non-disparagement or non-disclosure obligation. In order for employees to file a claim under the NLRA, they have to file what's called a ULP, an unfair labor practice, and they do that by submitting a charge to the National Labor Relations Board. And you can do it online, you can do it via mail, or I think still in person. And that's essentially the process you go through, and then an investigator picks up with the charge. They pick up all the charges that come in and would investigate whether they believe that employees' rights were chilled in that instance.
Would it invalidate the release portion? Do you know, like, do we have any sense of whether it would compromise? I'm just thinking from like a contract construction perspective, especially, again, a good reason to look at the miscellaneous provisions in your agreement, whether they're separability or severability type of clauses in there, to make sure that even if you have an issue, is there a way to insulate the release itself?
In theory, if you have a severability clause in your severance agreement, which everyone should, public service announcement, include a severability clause, that should carve out the non-disparagement and the confidentiality provision such that you don't undermine the entire intent of the agreement. That said, there was some, again, ominous language in the general counsel's memo that basically said, well, we're not going to speak to that. That comes down to state law. And I haven't looked at all the state laws that look at this, but I suppose you could have a situation where it scraps the entire agreement if it's found to be a necessary part of that agreement. And so I think most cases it should not undermine the entire agreement, but unfortunately it's going to be case by case.
All right. So what should employers know coming out of this? Update, take another look at what you're using. Like, what are the key takeaways coming out of this case?
And some of this is going to sound sort of like a broken record, as attorneys often do, but it's a good opportunity to dust off your severance agreement template, take a look at it. It's not just changes that we're seeing in this board law, but confidentiality obligations are changing across states, as are non-compete obligations, non-solicit. So it's just always a good idea to take a look. at these agreements, make sure that they are compliant with current federal and state law. It's also a good opportunity to look specifically at those non-disclosure and non-disparagement provisions we've been talking about. Make sure you have carve-outs for the protected activity that the board is looking for, and that should get you in the right direction.
Awesome. Well, that's it for us today. Clocking in with PilieroMazza. We'll see you next time.
Bye, guys.